you have coming in here talking about science and all that. You're an actor. You want to know what my first patent was? The entire AR VR world was built off of my first patent that was abandoned because I paid $260,000 for the worldwide patent. But then my agents kept not my lawyers kept sending me these maintenance fees and annuities, and I'm like, these folks are just trying to shake me down. I'm not going to pay this. Well, a year later, if you would pull up my
we gonna talk about it today. We gonna hey, look, I got the receipts. Now he talked about his patent went abandoned because he paid $250,000 because his attorneys paid or giving him. Well, first of all, he paid $250,000. He said to the attorneys, but then he said the attorneys kept sending him maintenance fees and annuities. He said, "Screw that! These guys trying to get over on me." As a patent attorney, again, if you guys don't know me, my name is Dave. I'm almost 10-year intellectual property attorney dealing with everything from trademarks to copyrights to NILs and yep, you guessed it, patents. Now, again, we're going to go through the paperwork because I pulled all the paperwork from the USPTO. We're going to figure out what really happened between Terrence Howard, the USPTO, and the attorneys. Some people are saying, I made a full video. Go check that out if you haven't already. Some people are saying in the comment sections that, hey, man, Terrence Howard is just crazy. Other people are saying, hey, the USPTO kind of, they screwed him over. They didn't give him his patent when they should have. He did create something, and hey, they called me. They just said I'm being a hater. I guess first and foremost, I'm just giving you all the facts based on my experience, kind of being in the game for as long as I have. I'm not saying one way or the other, but again, based on my experience and the things that I have witnessed and what I know to be true and not true about the USPTO and patents here in the U.S., I can say something is false or say something is true. Then the last part is people are saying that his lawyer screwed him over. So the first contingent is saying that, hey, Terrence Howard is crazy. The second contingent is saying the USPTO screwed him over. And the third contingent is saying that his lawyer screwed him over. We're going to go through the paperwork from the USPTO and see what really happened. But again, just backing up a little bit, he said that he paid his attorneys $250,000 for his worldwide patent. I'm not even going to get off into that again because we talked about it in the previous video. Go check that out as far as worldwide patent and can you get a worldwide patent. I'm not going to get off into that on this one. Again, the things that I do want to get off into, what actually happened between him and his attorneys to cause them to fall out. And he talked about paying $250,000. Hey, look, if I paid an attorney, and I am an attorney, a patent attorney, but if I paid an attorney $250,000, you better believe I'm going to have something to show for it. And I'm not even just talking about a U.S. patent. If I pay $250,000, I'm going to have a patent all over this joint in all type of countries, China, Europe, different countries in Europe, India, Mexico. I'm going to get a patent everywhere for the $250,000. So again, that's just me though. That's just me based on what I know about the USPTO and legal fees and things of that sort. You guys may differ with me, but I'm just telling you what I think as a patent attorney. And again, he also talked about maintenance fees and annuities, which I thought was odd because typically once your patent get allowed, you have to pay maintenance fees and annuities here, not only in the US, but wherever your patent is allowed. So if you have a patent in China, you have to pay maintenance fees and annuities to keep your patent active. And it's every so often. Here in the US, you have to pay maintenance fees at 3.5 years. Again, a patent is good for 20 years. So at the 3.5 year mark, you have to pay maintenance fees. You have to pay another maintenance fees at 7 years, another set of maintenance fees at 14 years, and then you're in the clear right there. Again, it's a similar thing in China and different countries where you may have a patent. And again, I'm not sure their schedule as far as when you have to pay those maintenance fees in those countries. But here in the U.S., you have to pay them at 3.5, 7, and 14 years. Now, the interesting thing is he's saying that his attorneys were kind of sending him over these maintenance fees and annuities that he had to pay. But again, he doesn't have a patent. We kind of talked about that ad nauseum in another video. He had a patent application. And he even talked about it. He said it went abandoned. So that's odd for me as a patent attorney, because you don't have a maintenance fees or annuities that you have to pay if your patent has been abandoned. Now, again, if you had a patent here in the U.S., then you have to pay maintenance fees. But to the extent that you don't have a patent, you don't have to pay maintenance fees. So that's odd to me already when he talks about, hey, they're trying to send me or give me these maintenance fees and annuities to pay. as if he had a patent because he didn't have a patent. So the only thing I can think of to try to make this kind of square that round hole is that they're telling them, hey, if you do get a patent, not only in the US, but in these maybe other countries that you want to go in, this is going to be what you'll have to pay in maintenance fees and annuities. Because typically, again, you file a PCT application, which he did file a PCT application. We're gonna pull up the paperwork. When you file a PCT application, you have to go into each country that you want to get a patent in. You have to file in each country individually, and they're going to go through an examination process. But then before that, all that happens, typically an attorney will give you, hey, what your fees are looking like to prosecute it in this country. What are the maintenance fees looking like in this country? So you kind of know a ballpark of everything that you're going to be out of. And maybe that came up to $250,000 for the maintenance fees and annuities. But again, you wouldn't have to pay that until you get the patent. This is the thing that I just don't understand what he was talking about, because again, your maintenance fees and annuities are not due unless you have a patent. He never got a patent, so I'm not sure why his attorneys were saying he has to pay these maintenance fees and annuities. Again, if you pay $250,000, you should have something to show for. But we're going to get off into the paperwork. The first thing that I want to go through is, let's see here, the office action. He did get an office action from the USPTO. We're going to pull it up. I'm going to explain to you what is an office action. For here, you see it here. This is an office action. You see it was issued on, hopefully you guys can see this, on October 10th, 2012. So typically, and again, and let me explain this a little bit. In Terrence Howard's case, he filed a PCT application, which means that he filed in, it's a PCT Paris Cooperation Treaty, and it kind of gives you this kind of worldwide, it's like almost like a worldwide patent application, not a patent, it's a patent application where all the member states of this Paris Cooperation Treaty, they are notified in a sense that, hey, Terrence Howard has filed a PCT application, and before a certain deadline, you can go into each member state that you want to get patent protection in. That's again a member of the PCT, the Paris Cooperation Treaty. So you can go into China, you can go into Mexico, you can go into Germany, you can go into India, whatever country that you want patent protection in. That's a member state of the of the PCT, the Paris Cooperation Treaty. You can file we call it nationalize it in that particular country. Again, now you don't have to. Now you can do it. If you file here in the US, you want to file in Germany, you can file directly in Germany, but you can also file just what is called a PCT application and then nationalize it in each country. It's more of a cleaner way. It's more of a streamlined way to file in the different countries that you seek patent protection in. So again, so he filed a PCT application, and obviously one of those states that he wanted patent protection in was the US. So in about 18 months from the non-provisional filing date, the examiner is going to pick up your patent application. He's going to review it. He's going to examine it. And then he's going to issue what is called a non-final office action. Typically, it's going to be a non-final office action. And what that means is, hey, he's saying that nothing is new about this patent or your patent application, your invention. Nothing is new about it. He's going to reject it based on some references to things that he was able to find, which we call prior art. And he's going to kind of describe all that stuff in what we have here, which is an office action. Now, he's going to, now, if we was to go down in his office action, you know, he has maybe some minor objections, but you have these 102 rejections. I'm not going to get off into the details of this office action, but just know in this office action, he's rejecting Terrence Howard's patent application because he's saying it's not new or it's obvious. That's what he's doing. And again, the date is October 10th, 2012. So you have 6 months to respond to the office action before your application goes abandoned. So in this case, he would have had to file a response to the office action by April 10th of 2013. Keep that date in mind. He would have had to file a response to the office action that was issued October 10th of 2012. He would have to file a response to that office action by April 10th of 2013. And if he doesn't respond to the office action, pretty much arguing why his invention is new, is novel, is non-obvious, in light of the art that was cited by the examiner, his application goes abandoned. But this is where the turn happens. This is where things start to get interesting. Let me stop sharing my screen. Look, I brought you guys the paperwork here. This is straight from the USPTO. I'm going to tell you guys what happened because it was a crazy turn of events. Let's see here. That's not the one that I want. Let's see here. Let's see here. Let's see here. You guys are not going to believe what happened here. Here we go. Right here. Hopefully you guys can. Let's see here. Is that the one I'm looking for? That's not it. Come on now. Here we go. Yes, it is. That's it. That's it. So what do we have here? I'm going to tell you exactly what we have here. As you can read the top left-hand corner, a request for withdrawal as attorney or agent and change of correspondence address. So what happens here? And again, this is dated. If we go to the bottom of this thing, where's my cursor? Here we go. If we go to the bottom of this thing, I don't want to out the attorney's name, but I'm going to do it anyway. It's public information, so it's not anything new. If you see here, this was dated November 27th of 2012. Now, what did we say earlier? The application, the non-final office action was issued November 10th of 2012. And just 1 month after Terrence Howard's attorney, they petitioned to the USPTO, the United States Patent and Trademark Office, to withdraw as an attorney for Terrence Howard. Now, as an attorney, that's some serious stuff. Typically, based on my experience, typically an attorney, that's a very rare thing for an attorney. I don't want to say it's a rare thing, but that's atypical for an attorney to withdraw as counsel for an applicant. Typically that happens because the applicant hasn't paid them or they just tired of the applicant stuff. I mean, there's been a few times that, hey, I have gotten clients and, hey, man, it's just not worth the squeeze. That lemon is just not worth the squeeze, or the juice is just not worth the squeeze of that orange, whatever you want to call it. That the client can be a little bit more problematic than you want, or problematic than what they're giving you, what they're paying you. And as a result, you just want to wash your hands with them and move forward. Hopefully it's amicably. Hey, let's come to an agreement. You're going to go your separate ways. I'm going to go my separate ways. But that's it's atypical as we're looking at here. And I want to bring it back up. We have a request for withdrawal as an attorney or agent and change of correspondence address. Again, which typically means that the attorney of Terrence Howard said, hey, we want to withdraw as an attorney for his case. Now, let me know in the comments, why do you think that was? Do you think it was because Terrence Howard was just kind of being too problematic, or do you think it was because Terrence Howard wasn't paying them? Typically, again, if I'm doing some work for you and again, you pay me, hey, it's all good. We are good. You're not causing me a headache. I'm good to go. We can kind of continue to do this thing until we, essentially until we kind of come at a crossroad as far as appeal or whatever the case may be. But typically, when you withdraw the services, is either you haven't paid me, or I'm thinking you should go one way and you don't think that you should go that way, and you have another course of direction that you want to go in this case. That typically is what happens. So again, we have that just a month after the non-final office action issue, which is crazy. The attorneys filed a request or petition to USPTO to withdraw as an attorney. So let's see what happens. So he requested. Now, as an attorney, you can't just automatically wash your hands with the client and say, hey, man, you are on your own. You have to essentially ask for permission from the USPTO. Let's see here. What does the USPTO, do they grant Terrence Howard attorney that permission, or do they not grant Terrence Howard attorney that permission? Now, again, to the extent that they say, no, you got to keep working, then a Terrence Howard attorney has to continue to act as counsel. But again, it's at the discretion of the USPTO. But this is what happened. February 7th, 2013. So the following year, they filed the request to withdraw on November of 2012. And then February 7th, let's read it here. The decision, this is a decision of the request to withdraw as an attorney or agent of record under, they give the CFR code, filed November 27th, 2012. So again, November 27th, 2012 is when he filed, or the attorney filed to withdraw as Terrence Howard's attorney before the USPTO. What happened? The request was approved. I'm not sure if you guys can see that. Let me try to blow it up. This request was approved. So the USPTO approved the request. Interesting. Interesting. Why is this interesting? Because now Terrence Howard doesn't have an attorney. So typically, if you're going to, going through this, obviously Terrence Howard knows that his attorney is petitioning the USPTO to withdraw. And at this point in time, I don't want to say astute inventor or businessman, you should be looking for new patent attorneys to come in. Typically, you will have a power of attorney over another case. Typically, when one attorney withdraws, typically what you see in the USPTO for the file is another attorney. Hey, they're going to submit or file what is called a petition or a power of attorney saying, hey, I'm his new attorney. I'm the new big bad sheriff in town. I got his back. That's typically what you will see. And then therefore, that new attorney will, they will respond to the non-final office action and prosecution will continue like nothing happened. Let's see what happened in this case, though. That typically is what happened. When one attorney goes off the case, typically the client has another attorney that is going to file a power of attorney, and he's going to say essentially to the USPTO, I have my client's back. Now I'm the new sheriff in town. I'm the new attorney that's representing, in this case, Terrence Howard. And therefore, you respond to the office action. You go back and forth with the USPTO until hopefully the claims get allowed. So that's typically what will happen in a situation like this. Let's see what happened in Terrence Howard's case. This is going to be crazy. Let's see what happens. I got the paperwork for you guys today, man. I did the homework. Let's see here. Is this it? Is this it? Is this it? That's not it. Come on, man. I probably should have had this stuff a little better put out for you guys, but we're going to get to it. Trust me, we are going to get to it. Here we go. What happened? So I'm not sure if you guys can see this. I'm going to blow it up. So this was what did I tell y'all before? This was mailed May 7th of 2013. What did I tell you guys? He filed the non-final office action was issued by the USPTO, rejecting the claims, rejecting the invention, in other words, to Terrence Howard on October 10th of 2012. He has 6 months to file a response to the office action, or else the case goes abandoned. That 6 months would have expired April 10th of 2013. Now, this mailing date of this office action was May 7th, 2013, which we know is after April 10th of 2013. So you can only imagine what happens. Let's see. Notice of abandonment. The case went abandoned. Come on now. Applicant's failure to timely file a proper reply to the office action letter mailed October 10th of 2012. Again, they're X in a box. No reply has been received. And this is the examiner here. Notice of abandonment. So they're letting Terrence Howard know that the case has went abandoned, which is crazy. Now, Terrence Howard made it seem like, okay, the case just went abandoned. He didn't really give any explanation to why the case went abandoned. But again, I just broke it down. The case went abandoned because it seems like the attorney, Terrence Howard, and his attorney was at a crossroad. I'm not sure if it was because of the money or they just had different ways or strategies of kind of going about responding to the non-final office actions. But anyway, that ultimately led to the attorney petitioning the USPTO to withdraw as Terrence Howard's counsel, which again, it happens. However, typically you will have the client, in this case, Terrence Howard, he will have somebody else that's going to file a petition of attorney, a new attorney essentially that he has waiting to essentially take over prosecution. Did that happen? No. What ultimately did that lead to? That led to the case going abandoned, or in this case, the invention, the application, the patent application being abandoned, and the AR/VR invention as it relates to Terrence Howard is not eligible for patent protection. Now, you can't revive it, but that's some exigent or extreme circumstances in which that happened. I've had abandoned or revived applications before, and that takes a lot of work between the client and his attorney and the USPTO. But you guys have to let me know, why do you think the case wouldn't ban, or why do you think Terrence Howard and his attorney withdrew as representation for Terrence Howard? Do you think it was the money? He said he paid him $250,000. So if I'm paying you as a client $250,000, we're gonna get at least one patent. And I already know, just based on how just kind of from the experience in the situation, I'm gonna get all type of patents for $250,000. I'm not gonna pay $250,000 to an attorney, which he said, let's pull up the paperwork. He said that he paid his attorney $250,000. If you guys are not believing, let's go back to the beginning. Let's go back to the beginning.
My first patent was the entire AR VR world was built off of my first patent that was abandoned because I paid $260,000 for the worldwide patent.
So again, and I gave him 250. He said he paid $260,000 for the worldwide patent. Again, I'm not going to get off into whether or not it's a worldwide patent, but he said he paid, meaning that he gave up that money, $260,000. Look it. If I paid that much money, you better believe that case is not going to abandon. Not without exhausting the appeals with the USPTO. Hey, I'm going through every hurdle it is to get a patent on that. My case is not going to go abandoned for failing to, we just saw the paperwork for failing to reply to a non-final office action when I just forked out $260,000. Seems like, hey, so I'm not sure. Was it the money, or in my opinion, I think that him and his attorney just had a difference of opinions as it relates to the restriction. As it relates to the strategy. In other words, I think his attorney was like, man, I'm not dealing with Terrence Howard. This is more of a headache than what it needs to be. And I would doubt that he paid $260,000, because again, if you pay $260,000, you're not letting your application go abandoned without responding to the first or non-final office action. That just doesn't happen. So I don't think he paid $260,000. Obviously, the maintenance and annuities that he claimed that they were sending him, that is, for the lack of a better word, BS, because he had no patent. You wouldn't have to pay maintenance and annuities unless you had a patent. And we all know that it went abandoned, so he doesn't have a patent. So again, the $260,000, to the extent that he did pay that, which I don't even believe he paid that. Yeah, I'm not sure. Look it. I saw the application. It was 34 pages. I just got done with a 40-page application just earlier today, and that cost the client less than 10 grand. So you're not going to tell me for a 34-page application he paid over $250,000. That just doesn't work like that. But in any event, let me know in the comment section, why do you think the attorney withdrew from the case? Do you think it was because of money, or do you think it was because Terrence Howard was just causing too much of a headache or a problem for the attorney, that it wasn't worth the service, it just wasn't worth the money that Terrence Howard was giving him, which again, the money wasn't $260,000, but that's another point. Let me know in the comment section what you think. Am I just totally off? We saw the paperwork. Non-final office action issued October 10th, 2012. A month later, the attorney filed petition to the USPTO to withdraw from the case. Terrence Howard has nobody lined up. That request to withdraw was approved by the USPTO February of 2013. In May of 2013, Terrence Howard gets an office action from the USPTO saying that the case went abandoned. Hey, I'm gonna play it one more time. Let Terrence Howard call it. He's gonna do it wrong. Let's go back.
People say, well, what business do you have coming in here talking about science and all that? You're an actor. You want to know what my first patent was? The entire AR VR world was built off of my first patent that was abandoned because I paid $260,000 for the worldwide patent. But then my agents kept.
Look, there you go. He made it seem like he paid the money. It was abandoned because he paid the money and they kept sending him bills. That just wasn't what the paperwork showed. First of all, he never had a patent, obviously, which is if it goes abandoned, you can't have a patent if the application went abandoned. But he definitely didn't pay $260,000 for it. And there was no annuities or maintenance fees for them to send him because it was no patent issue. So who's lying? Is Terrence Howard, is he leaving out some stuff, or I'm not sure. But like I said, I think that it was too much of a headache that he caused the attorneys to the point where only a month after the non-final office action issued, they said, heck, I'm out of here. Pieces, deuces. I'm going to petition the USPTO to withdraw, and they approved it. Terrence Howard didn't have an attorney lined up, which is, again, is something to take for it going forward. If you do for whatever reason decide to kind of break away or kind of go your step away from your attorneys, make sure you have another attorney lined up, because it's dates with the USPTO that if you don't meet, your patent application can go abandoned. That just, again, hopefully you guys, that's the tip of the day. Have another attorney lined up, because if you don't, that clock still is ticking and your case will go abandoned. So hopefully you guys got something good out of this. Hit the like button. Hey, hit the dislike button if you didn't like the video. Leave a comment. Let me know what you think. And until next time, hit the subscribe button if you enjoyed this content, and I'll try to give you more of this type of a content. So please hit the subscribe button if you enjoyed this content. We'll see you guys later. Peace.